We got great news to share with you again. ICE agreed to join a motion to reopen and dismiss removal proceedings for a case dated 2019, a removal case of 2019. In this video, I'll talk to you about the timelines, okay? What exactly we did, our approach, what state and how long it actually took. And we're so happy that my client finally go back to USCIS once the case is actually dismissed by the BIA. He can go to USCIS and adjust status, okay? So, my name is Bijoux Ngwanda, immigration lawyer here in the DC metropolitan area. We work with individuals across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, you go ahead and share, subscribe first of all before you share, like, don't forget comment below. Also follow me on all platforms, the TikTok, Instagram, Facebook page, Facebook group, and we try to provide as much value as we humanly can, right? Possibly can, okay? And we had a challenge, we posted 100 videos. Actually it's 99, but we are counting them 100 because we had a couple live sessions, try to get questions, try to answer those questions. If you had concern about any of those videos, we posted on TikTok and on YouTube, of course. We posted those videos so that we can answer the common frequently asked questions so that you can have an idea, get an insight. Just go ahead and visit my TikTok link in the description box and follow, of course, so that you won't miss out, right? You'll be informed. Keep post. You will know things about immigration, and you can make a really informed decision when it comes to your petition. Okay, you need guidance, of course. Yes, my client, as anybody else, you find yourself in removal proceedings, you make your case in front of the immigration judge. The case did not work out. My client was ordered removed. My client appealed the case, and then it was dismissed 2020. Again, how long it took? For this particular client took 1 year for BIA to respond. Some people, it takes forever, right? Like the previous case took 5 years, but this one took actually 1 year. BIA responded negatively, of course. They dismissed the case, and then my client has been trying to find a way to adjust status. So under marriage, of course, a family-based approved petition, married to a U.S. citizen. So my client came to me. I told my client, you gotta have some patience because we're trying to join ICE here. We have to join ICE. It's much easier if ICE agreed. It's really much easier that way, okay? So we tried to join ICE, filed the motion on April 28th, 2023 this year. We follow up only one time. This is Chicago. Say hi to my friend OPLA in Chicago. Those are the great people right there, Only one follow up, and then in June, on June 15, they actually answer us positively. They say, yes, counsel, we agree to join this motion, and just take the document and file with BIA. And then we already filed with BIA. Now we wait for BIA to respond, which we are anticipating. Again, a smooth transition with BIA. It's just a matter of the case being in front of a judge, and then the judge is gonna dismiss this removal proceedings. Then my client will go back to USCIS adjust status. How do you make your case? First of all, you gotta have compelling arguments, right? And you have, when we talk about compelling argument, it means that you have to have an approved petition and show that you can actually adjust status. Approved petition on the family-based immediate relative, U.S. citizen spouse, or U.S. citizen child over the age of 21 petitioning for you, right? If you are the parent. So those are immediate relative in terms of adjustment of status for this particular case. and my client is adjusting under a marriage. Okay, so if you have employment base, then you gotta find a way to convince ICE that you can actually adjust status, and that's by 245I, because you don't get the unlawful presence waiver automatically. Okay, if it's lawful permanent resident, then you have to have a waiver approved. Then you can convince ICE that you're gonna leave the country to do counsel processing from outside. So that's more challenging, right? But under family, immediate family, approved petition, no criminal record, really smooth transition. If you have crimes, then we have to find mitigating factors, show them how you have improved. If we can file for a waiver, make sure that the waiver gets granted first, then we can convince ICE much easier, you know what I mean? So stuff like that. So this is how you convince ICE, and once ICE agrees, that's it. This is it. Finito. It's a matter of there's no more resistance, at least less, on the part of the judge, in order for the judge to actually grant the motion and dismiss the removal proceedings. This is a big news and great news. This is it. So if you need a consultation about your case, we strongly suggest that you schedule a consultation, because this is not something that you can do on your own. You can if you want, but I spoke with one potential client the other day. He filed a motion to reopen on his own. Since 2019, he never got a response. Okay, I'm assuming he didn't even join ICE. So it's just gonna be sitting there, right? To be honest, you have to try to join ICE first. If ICE does not agree, then you can go sua ponte on your own, right? But it's better to get counsel. Schedule a consultation by using the link in the description box below. Then tomorrow, I'll be talking about administrative closing the case. What are the standards under the case law that we have? Yes, that's what I'll be talking to you about. But again, please share, like, don't forget to subscribe. Until next time, bye-bye.